Welcome to our channel. Today we have a very famous immigration lawyer named Cass to introduce about immigration in the time of COVID-19 for us. Him and his translator assistant Karen Arimoto will be here with us today. Without further ado, Karen.
嗨，大家好，我叫 Karen。那我是Podcast 律师楼的助理。我们今天要谈的题目是，在这个 COVID-19 期间对 H1B 的签证影响。那我先稍微介绍一下律师。律师呢，他是耶鲁大学毕业的法学博士，他是美国移民律师协会的会员，那也是洛杉矶律师公会2015-2016年的移民律师协会会长。我们有做一般的家庭移民啊，所有的移民方面的业务。还有我们做信托，就是帮客户做他们的资产规划，尤其是那新移民的资产规划都非常重要，怎么省税啊、避税啊这类的业务。然后我们有做商业跟民事诉讼。我们律师他处理过一个唯一在加州有登记的河豚中毒的案件，我们是原告的律师。我们律师会讲英文、中文。我会等一下，如果说有问题的话，需要用中文提问，那也是可以的。那我们律师会听西班牙文、法文跟德文。我们今天要讲的是关于 H1B 在这种 pandemic 的时候的问题。Okay, go ahead, Paul.
Yeah, thanks for the introduction. I do speak Chinese, but I never learned the vocabulary for legal things, so I don't want to pretend that I can. I'll just mess it up if I try to speak Chinese on these legal matters. So I don't want to embarrass myself or Karen, who's introduced me. So this is not a general immigration introduction. This has to do specifically with issues that I'm getting calls on practically every day or certainly every week regarding problems that arise because of the pandemic and the changes in, business practices. Schools are closing or going to remote online instruction and so on. And so what do? I being a person who's here on a non-immigrant visa, what do I do to stay in status or preserve my right to be here when due to circumstances outside my control? Generally, this does not apply to people who have green cards. People who have green cards have some things they have to comply with, but they don't have to specifically comply with any employment or education or other things. So this is for non-immigrant, Fei-Imin, and the main ones are students and H1B, which you may know about, other types of visas, and visitors, because those are the calls that I'm getting. So the first one is for students. And many of you may have been students here before on F1 visa or M1 visas. And you know that the visas, one of the basic requirements is that a student has to maintain a full course of studies, with some exceptions. Like, I get really sick and I can't go to class or something like that. A full course of studies generally means 12 semester units per semester for an undergrad student, 6 semester units per semester for a grad student. And there are specifically limitations. It's you can take 3 units a semester, basically one course. So ICE, Immigration and Customs Enforcement, which is the main agency in charge of student status and visas, Immigration Service is not the main one in this case, has said that those limitations are temporarily lifted and students can take all of their courses online if the school offers courses online. Some schools are better than others at offering courses online, and some students are better than others in being able to take online courses. But in the ideally a school, you can take all your courses online. What if a school can't provide the courses online? Well, there may be other methods of remote learning that may be doable. And one of the solutions is that in certain cases, a student can take less than a full course load without jeopardizing his or her status. Or they can do maybe independent study, sending in papers or something which satisfy this. Schools have to prepare a plan and give it to ICE and have ICE approve it. Okay, well, one of the things I'm getting is a lot of people, I'm getting two types of questions. One type of question is, hi, I'm a student, I want to go back to China or whatever, and guess what? I can't get a ticket, or there are travel restrictions, and I'm worried about getting back. So how do I, A, leave the country, but B, I went back because I want to be with my family during coronavirus. So the issue is, what if I went back to China or wherever, and I want to stay, I want to keep my student status, but I wanted to be with my family, or I thought it was better to be in Taiwan where they don't have any cases and nobody dying. Maybe it's better to be in Taiwan or China. The answer to that is that as long as you can keep doing remote learning, like online, the ICE has said that you can maintain your student status even outside the country while this crisis is going on. If you can't, then that's another issue. Now, what if a school closes temporarily due to the virus and they can't offer online instruction or other alternative learning procedures? ICE has said in general terms, they intend to resume their course of study when classes resume, and there's some kind of plan in place. They're not going to jeopardize their student status. So the school's cooperation in this is very important, giving a plan. And usually it's like they were given 10 business days to provide that plan. And so they're treating this sort of like, as you know, even if you're here as a student, you don't have to study over the summer. You can leave the country and go home during the summer. So there are ways to treat this as being basically like on a holiday break. So one of the things that students care a great deal about is employment, right? Generally speaking, a person who's here as a student is not allowed to work. And there are some exceptions, and the exceptions can be very important. One of them is frequently a student may be able to get on-campus employment in a school office, doing research for a professor, whatever. If the school's closed down, you can't do the on-campus employment. But ICE says that as long as the person continues to maintain a full class load and the work that's done can be done remotely, then the person can continue on-campus employment and maintain status. One thing that a lot of students are very familiar with is what's called curricular practical training, or CPT, where after the first year of studies for undergraduates and earlier for graduate students, a student can actually be allowed to work for part-time for up to 20 hours a week while continuing studies, as long as the work is in some way related to the studies. So what happens with the curricular practical training when the school is closed, or classes are in jeopardy? And the answer is, as long as it was authorized previously and it can be done remotely, it can continue to be done, and it can even be done outside the United States if the employer finds some way to employ you in some, work from home way, which a lot of employers are doing now with things like, Zoom meetings and email and things like that. Okay. But the biggest issue is what's called optional practical training, which is something that people get after they've graduated. There are two types of options. Well, there's also pre-graduation, but we'll not talk about that. Postgraduate optional practical training generally is for 12 months after you've graduated. People who are in STEM, science, technology, engineering, and mathematics majors that are on the USCIS and ICE list, which they publish, can also get a 24-month extension. STEM is, science, technology, engineering, mathematics. So if you can get the optional practical training with STEM extension, you can get up to 36 months of employment authorization after graduation.
Did you say 36 months?
Well, including OPT plus 24 months, 12 months plus 24 is 36.
Okay.
Right?
Yes.
One of the problems is, that OPT doesn't just let you stay in the United States. There are certain requirements. One of them is that if you're on the general 12-month OPT, you cannot have more than 90 days unemployment during your 1 year. And STEM may not have more than 120 days during their 2 years of unemployment. So there are a lot of questions. What if the business closes down? What if they fire everybody? What if I've left the United States? Does that mean automatically that I've also left employment? And after 190 days or 120 days, I'm out of status? So the answer to that is, for OPT, the initial OPT, there are a number of loopholes. You're allowed to be self-employed. You can do volunteer work as long as you can prove that you're actually doing it. You can do unpaid internships. There are all kinds of things you can do which do not involve you showing up at an office and putting in 8 hours a day. But for STEM, there are many fewer such loopholes. You can't be self-employed. You can't be doing volunteer work. You actually have to be employed in a STEM-type job. And there's a plan that you have to provide the government saying, this is what I'm going to be doing for those 24 months. So what can you do? One thing is you can switch to part-time. Another is if you can do remote work, you are able to do the remote work. Doesn't matter if you're inside the United States, outside the United States, you can continue to work remotely if that's possible. And generally speaking, if you're traveling or if you're outside the US, but your employer continues to pay you and continues to treat you as employed, just being outside the United States doesn't make you unemployed. So those are all possibilities. A problem is that what if the work site closes? What if you can't do the work remotely? There's no answer to that. You probably start accruing unemployment, and after 90 days of unemployment under OPT, or 120 days of unemployment under the STEM extension, you unfortunately have lost your F1 status. And there's generally not an easy way to regain it. And you've also lost the grace period, which I will be talking about later. So people who are on OPT or STEM OPT should do whatever they can to be seen as continuing to work. That's generally the main issues. Now, because of COVID-19, one of the issues I get asked all the time is, well, I mean, do I qualify for unemployment? If I get unemployment, does that somehow impair my status? What about the stimulus checks that the government is sending? Am I somehow jeopardizing my non-immigrant status? Or more importantly, not jeopardizing my status, but am I somehow going to be subject to what the government calls the public charge ground of inadmissibility, right? As you may know, starting earlier this year, the government enacted or imposed very stringent limitations on the kinds of benefits that you can get before you are considered to be what's called a public charge, which generally means getting means-tested public benefits, and that can ruin your chances for non-immigrant continuation, but also for immigrant visas. So the basic answer is every state has different unemployment benefit requirements. But unemployment benefits are not a public charge because you can't get unemployment benefits unless you've paid into the system. If you paid into the system, it's not like a government favor they're doing you. It's not like welfare, it's not like Medicaid. It's something you're entitled to. Stimulus checks, you don't even ask for a stimulus check. At least there should be no, well, maybe they don't send them out to everybody, but there should be no real issue with either of those in terms of the chargeability. But if you get unemployment benefits and you're on OPT, you're entitled to them, but that doesn't mean you're employed because you got unemployment. So that you can still start the 90-day or 120-day period of unemployment while getting the unemployment benefits, and that's not good. Okay, so what to do? One of the questions, and I get this a lot, is I really want to go back home. I can't get a flight out, or even if I could get a flight out, there's no flights to the place I live. My status maybe even is expiring, and I don't want to stay here illegally, unlawfully. So first thing is that for a number of different categories there are what are called grace periods. And these are periods after your status expires, which allow you to sort of wrap up your affairs and prepare to leave. And during the grace period, you're still in status for that period, although you're not allowed to work. For F1 and M1s, the grace period starts after the OPT. You get an employment card the day after the employment card expires. Otherwise, if you don't have OPT, it starts when you graduate. F1 students get 60 days. M1 students get 30 days. And J1 also get 30 days. J1 are what are called exchange visitors. You may be able to ride out the 60 days or the 30 days. Or even if your status is ending, during that 60-day or 30-day period, you can file an application to change your status. For example, change to a visitor, or if you're lucky, change to an O1 extraordinary ability, or an E1 investor, or something like that. Or you can even, if you're lucky, and it depends on the circumstances, you can file to go back to school. I'm taking some courses, so I'm maintaining my F1 status. Or I have an undergraduate degree. During this 60-day period, I'm filing to go to graduate school, or things like that. So that's a possibility. Crazily enough, J1 is run by the State Department, not really by ICE or USCIS. And the State Department basically says that in most cases, even after the program is ended, if a J1 leaves after the end of the program and the grace period, they should not be penalized when they try to come back to the US in some other status. I mean, that's the whole purpose of this, is you don't want to be out of status so much that when you leave, they're going to hold that against you and not let you come back because you've not been able to show that you have what's called a non-immigrant intent. One of the issues that we get a lot is H-1B. H-1B, as you probably know, is for what are called specialty occupations, for jobs that require at least a bachelor's or equivalent. The person has the qualification, and the employer pays the employee a wage that has been certified by the Department of Labor as not lower than what's called the prevailing wage in the government database, and usually higher. It's what's called the actual wage, which is the wage. In other words, you can't treat an H-1B worse than you treat regular employees. So if regular employees get a higher wage, the H-1B has to get one as well. But what happens with the problems that we're seeing with business closures due to the stay-at-home and other things? The employer has to suspend business operations. That doesn't somehow stop the requirement that the employee has to be working for the employer while he or she is in H-1B status. If the employee stops working for the employer, as a general rule, the employee is no longer in status. This can be a problem. This is especially a problem if the employer has to actually close down its physical location, like its office, its restaurant, its real estate agency, I don't know. If the business remains operational, in other words, we're continuing our business operations, we're just closing our brick and mortar storefront, and work can still be done remotely from home, then that generally should not be a problem. As long as the work from home location is within the basic geographic area that has been certified for the H-1B. One of the requirements for the H-1B is that you get what's called a labor condition application certifying the wage for the specific general area of the employment, which is usually the same county, metropolitan statistical area, reasonable driving distance. So if my business is in Los Angeles and I have an LCA for Los Angeles, but I'm living in Orange County and working from home, you're probably still okay. But if I'm living in San Francisco County and working from home and my LCA is only for Los Angeles, the employer has to file an amended petition paying the filing fee to allow the person to work from home. without getting into trouble. One thing that a lot of employers try to do to save jobs is, well, we're going to cut wages across the board, right? We got a 10% pay cut, a 15% pay cut. We want to keep the jobs, but they can't get paid as much. Problem with that is you can do that with people who have green cards or employment cards like, well, students on OPT, but you can't do that with H-1B because H-1B employers are required to pay a specified wage that is certified by the Department of Labor. And so what do? Well, one possibility, which really has not been tested in the courts, but which has worked in the past, is, yeah, we're cutting everybody's wage, but the H-1B person's wage is still going to be above the government prevailing wage. So if everybody's wage is cut and the H-1B wage stays above the prevailing wage, that probably is okay. If it goes below the prevailing wage, that's a violation. Another alternative is, well, we're cutting the wage right now, but we promise you, not just we hope, we promise you when this is over, we'll give you a bonus to make up for the difference. So as long as it's a guaranteed bonus, that probably works because a guaranteed bonus can be part of an approved wage. But again, it hasn't really been tested. Another possibility, as long as the business remains open and the person, let's say, is a full-time H-1B worker, a person can be, H-1B is also available for part-time work. And so if you want to change, you can change the person from full-time to part-time and pay the part-time wage. But in that case, if it's a material change, the employer also probably still has to file an amended petition, but that's doable. What about furloughing workers, which is not the same as cutting them, but we're sending them on a brief hiatus. We're sending them on a sort of a vacation. We're furloughing them until the business gets better. That's doable. H-1B workers still have to be paid. If it's an unpaid furlough, it's the same as basically terminating the H-1B employee, and that is probably a problem. And that would render the H-1B worker probably out of status. Now, there's also a grace period for most non-immigrant employment-based visas like H-1B, like L-1, O-1, E-2, I, and that grace period during the validity of the H-1B is 60 days. So basically the idea is, I got fired, I got laid off. You have 60 days to find a new job and for the new employer to file a new petition, and you'll still have maintained your status. If it's more than 60 days, a new employer can file a new petition, but you may have to go back to the home country to get an H-1B visa. But if you do it within 60 days, you should be okay. For H-1B, O-1, L-1, E-2, E-1, etc. And so there are, I mean, obviously, if you can find new work during the 60-day grace period and file a new application, you're probably okay. You don't have to leave the country. Everything should work. If it's more than 60 days, then you've been out of status for some period of time. The Immigration Service may approve a change of employer, but make you leave the country to get a new visa. And when I say change of employer, I mean, it's quite possible for an employer to terminate you because they can't pay you. And an H-1B employer wants to terminate you so they're not liable for all of the wages that are required. But then they want to hire you back, in which case they would have to file a new petition after they hire you. Because when they terminate you, they have to send a letter to the Immigration Service, and they also have to offer the employee one-way ticket back to the home country. Okay, another possibility, which I've used in the past, we don't really know how this will work, is, okay, what if the employee says, well, you know, I'd like to request a leave of absence. I want a voluntary unpaid leave of absence. the regulations basically say leave of absence, which is unpaid, is allowed if it's for the benefit, if it's at the request of the employee, it's for the benefit of the employee, not for the benefit of the employer. The examples that are used are, I have to go on maternity leave. I've been diagnosed with COVID-19 and I have to quarantine for some period of time, or I have to have holiday, or I was in an accident and I've got to recover from the accident. The employer not being in business probably is not contemplated by that. But if you're creative, you can probably work out a reason for an unpaid leave of absence, which would keep you in status. The only thing is the Department of Labor and the Immigration Service one day might send somebody to the employer's door and ask to see the documents that document this unpaid leave of absence to see if it was legitimate. So but that's another possibility, which I've used in the past once or twice. Can a terminated or furloughed H-1B employee claim unemployment benefits? Well, they paid into the system, so they should be able to. The only problem is that in most states, a person who gets unemployment has to show that they're ready and available for work. An H-1B can only work for the sponsoring employer. So getting unemployment benefits may very well be a violation of the H-1B status. Again, nobody's tested this yet, but and the regulation is unclear, but I think a majority of immigration attorneys would say this may jeopardize H-1B status. Now, what about an H-4 spouse who has work authorization? H-4 spouses get work authorization when the H-1B has a labor certification approved, or what's called an I-140 petition approved. So the H-4 spouse can apply for and get employment, work authorization, get an employment card as long as the H-1B spouse stays in status. And the answer to that is the H-4 spouse is not required to work. So an H-4 spouse should absolutely be allowed to get unemployment insurance. That shouldn't be a problem. But the H-1B may be a problem. What about these other visas I mentioned? L1, E1, E2, O1, et cetera, et cetera. Well, the H-1B, and I don't know, the slide is wrong. It should be H-1B1, which is a special H-1B type for Singapore and Chile, and E3 for Australia, all require a specified wage. So if the employer doesn't pay it, that's a problem. Other employment that doesn't necessarily require a specific wage. Government doesn't have to certify what the wage is. So there should be some flexibility in allowing the employer to cut the wage, reduce work hours, work from home, and so forth. But if they actually close down and none of this is the case, you still have the 60-day grace period, and you have to think about what you're going to do. You got to do something within that 60-day grace period. But there should be a lot more flexibility in all of these compared to the H-1B and H-1B1. One of the types of questions that I'm getting a lot, maybe there are fewer now that we're 2.5, 3 months into COVID and most people have solved their problem, but a lot of questions I get are from visitors who are on what's called a B visa, or people who are on what's called a visa waiver. Something they call it ESTA, which is the application. ESTA people come from countries where they don't need visas, and they're allowed to enter the US as visitors, but it's a very strict 90-day period. ESTA visa waiver people cannot file to extend their status. There's nothing in the regulations that allows it. But a B visitor can try to extend status by filing a form I-539 with the government. As long as you file at least a day before your status expires, you're probably okay. It takes many months for the government to process these things. And while you're in the United States, while they're processing it, you're legally inside the United States. That doesn't mean you're in status. Being in status means that you have some kind of approval or some kind of admission to a certain date, but you're not illegally here until they make a decision. And that's very important because under the law, if you are not lawfully, if you accrue what is called presence for more than 180 days, leave the country, you can't come back for 3 years. If you got more than a year, you can't come back for 10 years. So it's very important not to be here unlawfully, whether or not your status continues. So with the B extension, you can get up to 6 months. And if they haven't made a decision by then, or if they've made a decision by then, but you still can't travel because the second wave of COVID-19 has happened, there is a possibility, again, a possibility, to explain to the government that this isn't my fault. I can't leave. I want to leave. I don't want to be in violation of the law, but I just can't leave. They can give you a further extension for humanitarian reasons. But it's important that you file on time. If you file after the status has expired, then you've got other problems. Okay, what about ESTA? By law, there is no extension. The Immigration Service cannot grant an extension for even 1 day for visa waiver entrance. You're not allowed to extend your status, right? I'm in the hospital. I can't get a flight back to China, or whatever country you came from that allows a visa waiver. And so I'm stuck here. I don't want to be here illegally. What do I do? Well, the CBP, which is Customs and Border Protection, which runs the airports and ports of entry, and the Immigration Service are allowed to review on a case-by-case basis application for what is called a satisfactory departure, which is not a true extension, but it's something saying, we understand you can't leave, we'll give you up to 30 days after the day to leave. And say that you've got to do that application no earlier than 2 weeks before the end of your 90th day. And the different ports of entry, depends on where you came in, different ports of entry have their own forms for doing this that they have recently created. A lot of times it can be done online. You have to prove that it's an emergency. You have to really prove that you can't go back. I can't get a ticket. I'm in the hospital with COVID. They generally have been okay with that. Immigration Service says they will do it too, but there's no way directly to contact the damn Immigration Service because all the offices are closed. So what you have to do is there's an 800 customer number, and you specify, I am seeking a brief extension for the ESTA visa waiver, and they can, on an emergency basis, make an appointment for you at one of the closed offices. So it's possible, but personally, I would go with CBP. The problem is, what happens if you've got that 30 days and you still can't leave? I think you are limited to the Immigration Service. So just be aware of that. Yeah, somebody asked about the L1 visa, which is not directly the subject of this. And L1 visa is a very popular visa for certain types of people. And a reason that it is very popular is that a person who has an L1A, intracompany manager or executive visa, who meets the requirements, can have the US company file for a green card for them without having to go through what's called labor certification. Most other types of green cards require going through Department of Labor, labor certification, testing the market, and so forth. But L1 to EB-13, which is the immigrant visa, does not require it. For our purposes, we only care about L1A, which is manager or executive, can have the company apply for their green card directly. People who have L1B, which is people with specialized knowledge of the company's processes or products, basically have to go through labor certification. So I'm not talking about them. It is not a true investor visa, but basically, of course, the US employer applies for the individual. The requirements are the person is a manager or executive at a company overseas, has been a manager or executive at that company for at least 1 year, is coming to the United States to work as a manager or executive for a company that is related to the overseas company in a specified way. The usual relation is the company overseas has either started up or purchased or invested in a company here and owns at least 51% of the company here. So they are the U.S. company is the subsidiary. This is not an investor visa like an EB-5 or an E-2. So there's no specified amount of investment, but the Immigration Service is very interested in knowing that there is a level of financial commitment so that a person can actually function as a manager or executive, which means there are people to manage and people, people to be an executive over. So you get a company and basically you don't have any employees. That's going to be a problem. Or you have employees, but they're all warehouse workers or floor sweepers. That's going to be a problem. So you're certainly going to want to have an investment and a business plan that shows that you are going to have investment enough and business enough to be able to employ people for the person to manage. And I cannot give you a specific dollar amount, but certainly in most cases, $200,000 to $300,000 for that kind of a visa would be a minimum, plus a solid business plan showing, yeah, we're gonna develop the business. And the visa is given for a startup company, it's given for 1 year. Then you apply, you can get extensions up to 2 years at a time to a maximum of 7 years. Plus you can add in days you spend overseas. So if you're here 6 months a year, you can keep adding those 6 months and 6 months and 6 months. I guess theoretically, you never reach the end of 7 years because you can just keep adding those days. Mm-hmm. But if it's not a startup company, you get an initial 3 years, but again, it's 2 years, 2 years, 2 years, up to 7+ days outside the United States. So as I said, this type of visa allows the U.S. company to apply for an immigrant worker status for a person, but there are some there are some limitations. One of the big limitations is the company actually has to have been doing business for at least a year before you can even start doing that business in the United States. Mm-hmm. Another requirement is that the person was a manager or executive outside the U.S. and is going to be a manager or executive inside the U.S. Because for an L1A, you can be somebody who was a specialized knowledge employee overseas and you become a manager here, can't apply for the green card in the same way. You have to have been a manager or executive in both companies. And the foreign company has to remain in existence and doing business during the entire process. It can't just sort of stop doing business. So the earliest date that an employer can file the immigrant employee petition is 1 year after the company started doing business. As a practical matter, that may or may not work because you still want to have the business developed to the point where you can prove that the person is actually a manager. So if the company still only has 2 or 3 employees or whatever, that's basically going to be a problem. Or if the company's really not making any money or doesn't even have like a gross income that shows that they're at least doing a lot of business, that can be a problem. So as a general rule, you would apply after a year, when the company is sufficiently developed. Now, that is the company petitioning for you, and that is important because the day the company petitions for you is the day that you get into line. For immigrant visas, basically, there are cutoff dates based on when you started the process. And so your cutoff date is the day the company files for you. But that doesn't mean you can apply for a green card at the same time. The Department of State publishes something called the Visa Bulletin every month, which says what the cutoff dates are. So let us say that your company files a petition for you today, right? You've been here, the company's been in existence for a year, you've been here as an L1A, we filed a petition for you today. You can't file for a green card until the cutoff date catches up. For China right now, the cutoff date in that category is backed up to October 2017. So you can't file for a green card until your cutoff date catches up with the government cutoff dates that are in the visa bulletin, which means you're looking at 2.5 years, maybe longer, which is why it's very important to be able to maintain status while you're waiting for those numbers to catch up. And that is why with the L1, one of the good things is, like I say, every day you're outside the United States, you can add that on to your 7-year limitation. And they call it recapturing of time outside the United States. You can probably keep this going long enough to catch up. People from China can't have the E2 investor visa because the United States doesn't recognize China as one of the countries for which that's allowed. Other countries are like Russia, Brazil, India. One thing that some Chinese people are doing now is they're getting citizenship in countries, they're buying citizenship in countries that do allow e-visas, for example, Grenada, which that's outside the scope of this. So if you become a citizen of another country, you can probably get another kind of visa that doesn't exclude people from China.
Thank you for watching. If you like the video content, please support us by like, subscribe, and share our link. If you have any interesting topic that you would like us to discuss in the channel, please leave a comment below. I will answer them for you in the future series. Until next time, bye-bye.